So we are here today in, it's hard to believe that it was less than a week ago that the Supreme Court's historic IEEPA tariff decision came out. We have been seeing so many questions from people asking, what do we need to do to protect our right to the refunds? What do we do with regard to counterparties who are asking us to take steps to share the refunds? Or what do we do if we indirectly paid the refunds and we want to get a piece of them? Do we need to protest liquidation? Should we be filing post-summary corrections? I mean, the number of questions has been absolutely immense. So we thought what we would do is do a presentation in two parts on this. So today we're going to be covering what the Supreme Court decided and what steps people should be taking with regard to preserving their rights to the refunds. I am the chair of the Foley and Lardner International Trade and National Security Practice, where we cover the full gamut of the international trade needs on both the export and the import side. So that means export controls and OFAC sanctions and FCPA. But lately, as you would imagine, it's covering a lot of customs and tariffs. I'm accompanied by John Trelay, who is of counsel and in our Milwaukee office, and we work together on many customs and tariff issues, and also by Hillary, who is an associate who has been playing point guard on filing these 1581I protective CIT actions, which we'll be talking about later. We represent over 100 companies in these tariff suits, with somewhere around $1 billion in IEEPA tariffs paid. So that is a good chunk of money on anybody's balance sheet. So we have been paying a lot of attention about this and fielding a lot of questions. So we want to try to hit all of these issues in kind of a broader way to give the importing community insight into the type of issues that companies are thinking about. So the first question that comes up is a lot of people are saying, you know, I've been reading about the Supreme Court's historic IEEPA tariff ruling. What does it mean? Which is the starting point for understanding exactly what tariffs are potentially being refunded, what tariffs are not potentially being refunded, because we have three major tariff authorities that are in play right now. And only one of them was invalidated. So we thought we would start with a little bit of an overview of what the Supreme Court decided. Now, if you take a look at the Supreme Court's decision, it's 170 pages, but about 110 of it is on the justices arguing about the import of the major questions doctrine. When it comes to the actual decision, it's actually fairly straightforward. I believe the main decision is only 21 pages, which is a model of clarity by Supreme Court standards. And basically, the decisions break down into three-part determinations. You have the first determination where the Chief Justice Roberts and Justices Gorsuch and Barrett ruled that under the major questions doctrine, Congress has to speak clearly when it is delegating something that's really important, like the right to impose tariffs. And the IEEPA does not mention tariffs, therefore it's not up to the court to basically read that in. And then you had the justices, the three liberal justices, Jackson and Sotomayor, ruling we don't need to go to the major questions doctrine, but just looking at the plain language, we can see that it doesn't mention tariffs, so that authority shouldn't be there. And then the last three justices, Thomas Alito and Kavanaugh, said basically we dissent and we find that the executive does have the authority to do this. So the specific tariff program that was invalidated by what is essentially a 6-3 decision was with regard to the global and reciprocal tariffs. That's like the 10% baseline tariff plus the country-specific reciprocal tariffs. And then there was also the fentanyl-based tariffs against China, Canada, and Mexico, which are in some way, shape, or form partially suspended or were up until Monday. Now they're completely gone. And then there was a couple of miscellaneous tariffs where President Trump had used them for like negotiating leverage, like the tariffs against India, for example, for purchasing Russian oil. These have now all been revoked by the executive order. And as of February 24th, CBP has stopped collecting the IEEPA tariffs. So they are now dead. The administration has complied with the Supreme Court's ruling in that way in terms of not collecting any ongoing tariffs. As we'll talk about later on in the program, they've replaced them with other tariffs, but they're at a generally lower amount, and they're probably temporary bridge tariffs. But the IEEPA tariffs have lived, they were born, they lived their lives, and now have died all in less than a year. So the question that comes up is, okay, what about the approximately $160 billion in duties? And the reason why that comes up, in part, is that the Supreme Court did not say anything about the refunds. If you search for the word refund, then what you see is that it only comes up 3 times, and always in the dissent, where the dissent basically complains to say, the majority didn't do anything about this, and this is a really big topic. So as a result, the court almost certainly deliberately did not determine whether importers are entitled to refunds, whether relief applies universally or only to the plaintiffs in that particular case who brought it, which is only a handful of companies, whether administrative exhaustion is required, such as by filing like a protest against liquidation, or the mechanism for repayment. Instead, what they did was they kicked the case back to the Court of International Trade, which is where the action first was filed, basically to take actions that are consistent with what the Supreme Court had ruled, which is that the IEEPA tariffs were unlawfully imposed from the beginning. So then there was a press conference where President Trump complained and said, that you think they could have dealt with this issue, and he was correct, because the issue was brought up during oral argument, and it was very squarely presented. And there also was another issue which was not determined at all, which was there was a disagreement between the Court of International Trade, which granted a preliminary injunction, basically saying that it was giving relief to everybody who had paid the IEEPA tariffs, and the Court of Appeals for the Federal Circuit, which upheld the general ruling of the CIT against the IEEPA tariffs, but rejected the idea of the CIT imposing a nationwide injunction. That also was not covered, which leaves some ambiguity as to what is going to happen. We did see over the weekend that the Treasury Secretary specifically stated that the administration will follow the court's direction regarding refunds. I kind of read that as a way for them to not do anything right now, to say, look, we're just waiting, rather than issuing a pronouncement saying we are ordering CBP, for example, to start refunding, which the administration could have done. And they're clearly sidestepping that, but they are on record saying that they will follow the court's direction regarding refunds. It also is true that in the litigation at the Court of International Trade and the Court of Appeals, that the US government stipulated that it would be willing to give refunds depending on the ultimate ruling, and that in one of the early 1581I cases, it repeated that stipulation and even said that it wouldn't be opposed to the court order that would say that it was reliquidating all entries and providing refunds with interest. And the Court of International Trade said, look, we're going to hold the government to this. That being said, the precise mechanism or what the meaning of that is still to be determined. We are seeing various legislative solutions that are proposed that would require refunds. Some of them say starting with small businesses, but all of them saying it's time to order the refund of the duties. Refunds would go, by the way, to the importers of record. The Court of International Trade is not going to be hearing arguments from consumers saying, well, wait a minute, someone passed the tariff on to me. That's not the way that the Customs Service is able to process refunds. So right now, it is not clear what the avenue is going to be. The government has a lot of wiggle room regarding how it will proceed. I suspect that there will be a push within the U.S. government to say, you know, we really should have some kind of opt-in mechanism because that would recognize that, especially for like smaller importers, that they may not actually take action to claim their refunds, and you know it might be like $100 or $200, but add that up over millions of entries, and it's not hard to get to billions of dollars that would basically default to the U.S. Treasury. So I suspect that's going to be a piece of it, that they're going to say, you know, people should have to opt in some way. We don't know if, you know, one possibility would be an administrative refund mechanism could be set up. Another possibility could be that they could entertain protests against liquidation and basically just say, you know what, we have a mechanism where people can seek refunds and we can just adopt it here. People can file protests against liquidation within 180 days of when liquidation would occur, which is normally around 314 days after entry. And so that gives people a 6-month window. Why mess around when we already have a system? That also has the advantage from the government perspective of being an opt-in mechanism. But on the other hand, it would tend to overwhelm CBP, which has to consider each of those protests as they come in. And it also has the downside from the perspective of people who are filing the protests against liquidation, that the U.S. government, or sorry, CBP, which is obviously part of the U.S. government, has 2 years to actually issue the refund. And a lot of companies are saying this is a lot of money. We don't want to wait 2 years. It's also possible that, and I would say probable, that there's going to be some kind of Court of International Trade supervised mechanism. And then, of course, the issue of the timing comes up. At the oral arguments, Justice Barrett raised the issue about refunds and concluded, so basically what you're saying is that the refunds will be, and this is her word, a mess, to which my thought at the time was, yeah, it doesn't have to be a mess unless the administration kind of wants to make it a mess, but it very certainly will be slow. And that's because there's over 300,000 importers that have paid the IEEPA tariffs and over 20 million entries that have come in if you include the entries that have liquidated. So it's even with good faith all around, it is going to take a fair amount of time. So to deal with all these uncertainties, a lot of companies are considering filing 1581I protective actions at the Court of International Trade. And it's publicly available information that a lot of big name companies have filed these actions, including companies like Goodyear and Revlon and Costco. FedEx filed earlier this week, all public information. And as I said, Foley has filed for over 100 companies. So the question comes up is, okay, if there is a remand to the Court of International Trade, why are companies filing these protective actions? And a lot of it is to deal with the uncertainty. Because as I said, right now, we don't know if the refunds are going to be automatic, if there's going to be a nationwide injunction. We don't know if relief is going to be initially, limited to just the plaintiffs in that case, and everyone else is going to be put into some kind of administrative protest mechanism. We don't know the role of CBP, and frankly, there's concerns about what is the Trump trade team going to do? Because the Trump trade team in general has been in the process in the last year of like trying to collect tariffs, and the presumption is they're not wild about returning tariffs. So the litigation has now moved to the Court of International Trade to help answer these questions. So, the basically importers currently face 4 options. And by the way, these are mix and match, not like choose one, like you might see on the SAT or something like that. One of the actions is you can file a protective action at the Court of International Trade under 1581I. And what you're basically doing there, the reason companies are doing this are fourfold. First, a lot of companies are saying, we kind of would prefer if we had an independent Article 3 judge overseeing our claims rather than the Trump trade team, which has been trying to push up tariffs. And we feel like we would just feel more comfortable, because it's millions of dollars, to have that kind of independent oversight. The second reason that companies often are filing is because they're saying this gives us an additional avenue to seek relief. And that's really important to us because this is a lot of money at stake. We don't know what's going to happen with regard to those administrative options, but we just want to maximize the number of avenues that we have. The third reason is there's a decent chance that these actions will result in a quicker refund. In other words, in other cases where Trump tariffs have been invalidated, like in the Trans-Pacific case, which involved like a very specific Section 232 executive order in the first Trump administration, at the end, the court just issued an order, said, okay, CBP, just refund everybody's money who filed the suit. And the court could even do that. You could request and say, have them do it within 30 days or 60 days or something like that. And especially compared to the option of maybe needing to file a protest against liquidation, which, as I said, can take up to 2 years. That can be pretty attractive, is to try to get that money quicker. So that is the third reason why a lot of companies are filing. And the fourth one is people are just saying, you know what, it doesn't cost that much money, and we've got a ton of money at stake. I just need to take every possible action to preserve my rights, particularly since like my CEO is seeing like our competitors are filing and things like that. Like I just need to be part of this if this is a way of potentially getting our money quicker and sooner, quicker and getting it there. Another advantage is if you were to file like protests, they're kind of individually reviewed. So the money could be coming in like dribs and drabs, over a long period of time. Whereas if the court issues an order, then they're going to do something like you need to file within like 30 or 60 days or something, and the money will come in a much more orderly and quick fashion. The second option is it also is possible, and this is one that companies who have less money at stake are tending to do, is saying, well, maybe we can use the normal correction mechanisms. Like, why couldn't we file a post-summary correction, which is basically what you can do. You have 300 days after your goods come in to basically take your original 751 entry summary form and, rhetorically just rip it up and throw it out and replace it with a new one. So you could file a PSC, your original entry included the IEEPA tariffs, and you refile and say, oops, sorry, we made a mistake. We now know the IEEPA tariffs are not valid, so we want to refile that. The advantages, these are very quick. The disadvantages is everything we are seeing is that CBP is denying these, which makes sense because they have, even though PSCs are basically like a thumbs up or a thumbs down and they don't spend a lot of time on them, I'm sure they're getting thousands and thousands of these. And so they're basically just denying these. They don't have the bandwidth to handle them. And it's also not a final determination because you still have the option of potentially protesting liquidation after the PSC period is over. Right now, we don't know what's going on with regard to protests against liquidation on the basis that they are unlawfully collecting the IEEPA tariffs. For the very earliest fentanyl-based tariffs, the 314 days has passed for some of those entries that occurred like in February and March of last year. But as far as we can tell, they're kind of going into a black hole because CBP has that 2 years and they're just like, yeah, even in the best of times for like a routine protest, like, oh, sorry, we misclassified this. So we overpaid by $2,000, even though it normally take 2 years. And so there's no reason to think these are going to be any quicker. Plus, the CBP is probably waiting to see how the litigation comes out. So that is a possibility. And for companies who have not filed 1581I actions, we 100% are recommending that you take some kind of action to preserve your right, which would involve filing a protest against liquidation. Your customs broker can handle these. You don't need a lawyer to do this. And they can do them on a batch basis. I believe you can do up to 50 at a time. So for, companies, you might be like, you can do a month at a time, for example, and just file a batch of them. And your customs broker is basically going to just be like cutting and pasting, to do it. I think you can designate a lead entry also. But basically, you're just going to say, hey, these are IEEPA tariffs. So we're protesting on the basis that you owe us the IEEPA tariffs. Another potential mechanism is to wait for government guidance. If you haven't signed up for CSMS, the cargo service messaging system. I don't actually know what it's called because everyone just calls them CSMS, but I think that's what it is. But you can sign up for guidance to where CBP puts out its advice to the importing community. They almost certainly are going to be sending out CSMSs on the issue of the IEEPA tariffs. It's possible there'll be some kind of administrative solution. It certainly hasn't come out yet. It may take a while. It may be done under court supervision, but that's an option. But again, if you should be tracking your IEEPA entries, and as they're getting close to the time for liquidation, like don't gamble on the government doing the right thing. Instead, take proactive steps to protect yourself by filing that protest, unless there has been some kind of definitive guidance put out saying, what, this is going to be handled in a different way, so you don't need to protest. The final option I should mention is there actually are active companies that are now buying these claims, and the value of them, as far as we can tell, has basically doubled over the last 10 days. They were being purchased at about 20 to 22 cents on the dollar is what we were anecdotally hearing. And now they're in the range of 40 to 50%. This isn't based on like concrete transactions that we are seeing. Rather, it is based on people basically saying, can you put me in touch with your clients? So that's what's going on there as well. So those are potential items as well. Now I can see that there's a bunch of questions that are here, and since I'm actually on time, let me answer them. We had a question: when you file for protective actions to CIT, can you do it for liquidated and non-liquidated IEEPA entries? And the answer is yes, you do cover both. What you're asking for is we want every single penny of every IEEPA tariff that we ever paid to be returned to us. The next question we got is, would the protest against liquidation be filed once entries are liquidated within the protest 180-day window? The answer there is yes. You can't file a protest until the entries have liquidated. That's what the PSC period is for. And then once they liquidated around that 314-day mark, then that's when you can file that protest. And you do have a 6-month window, which is why you can still wait right now to see how things develop. Can you do strategic pass for the importer to do multiple ones of these? Yes, you can. And I can tell you that we have clients who have filed the 1581I actions who are strongly considering belt and suspendering this to also file protests against liquidation. just because they're like, we want to do whatever is possible. In theory, that should not be required because the Court of International Trade said, you know what, even though liquidation is final, we are the court, so we can order reliquidation. So in theory, you don't need to do that, but that's still something that people are doing just because of the amount of money at stake. The next question was a protest option not already foreclosed by the CIT in a ruling. That's a reference to the December, I want to say 17th, ruling of the Court of International Trade on the motion for a preliminary injunction. And the court said the reason why we are able to grant and take these cases under 1581I is because it is not available for people to go to CBP and say the IEEPA tariffs are unlawful. That's not something CBP does. So at that time, the CIT was saying you can't file a protest. That's why you can go under 1581I. But they have not issued an opinion on the current question, which is now that the Supreme Court has issued its determination, would you be protesting on the basis that IEEPA tariffs are unlawful? Instead, you would be saying, hey, the Supreme Court already ruled on this, so it's a yes or no question for CBT. So arguably, you could file a protest now. But we don't know what the CIT's opinion is going to be on that, and we don't know what CBP's opinion is on that. It is possible that they will reject the protest, which is why we're calling this like the belt and suspender option. It's one of the ambiguities that are not out there. In my view, the fact that the court did not, Supreme Court did not address the issue of refunds means you can still file under 1581I, because right now there is no mechanism to say to CBP that you've been ordered to give refunds, because the Supreme Court didn't address that. For those that cannot file CIT actions, are there any options for refunds of liquidated tariff entries, or may the CIT implement a path? The CIT is going to have to consider that issue in the global IEEPA action, which is how do we, can we issue some kind of nationwide injunction or some kind of global remedy, which is what was done with the harbor maintenance fees in the 90s. I'm really dating myself because I actually was an international trade attorney at that time, and that which was much more complicated, by the way, because everything wasn't done electronically. What we are arguing and pushing for, though, for the companies that have filed 1581I options is to say, our case is much simpler. You don't need to get into the issues. You just need to consider, do these parties who are before you? So get a right to refunds. It's one of the reasons why our clients filed these cases. So what we are doing is trying to use the platform we have here to say, this is a much simpler case. Please just issue summary judgment. Please just give our clients the money because they are directly before you. And you don't need to get into all the issues in the main case that you're considering, because our case is so simple. But in the overall litigation, yes, the CIT will be considering that issue as well. And I see. And then lastly, what is the incentive for companies to sell their claims, expedited access to money? Yes, that is exactly the reason. In our view, now that the Supreme Court has spoken, we've gone from a two-part question to a one-part question. The two-part question was, are the IEEPA tariffs illegal? And the second one was, if they're illegal, what's the mechanism and the timing? We now know they're illegal, so we view the refunds as being pretty close to certainty, and it's just a question of timing. So companies may, for cash flow reasons, be and the uncertainty as to how quick things will happen, be considering selling these off as well. So I will stop there, and let's see, is there? We already kind of covered this. So I want to turn things over to Hillary to talk about the topic of the steps that importers can consider, At the end, I will be coming back on to talk about a wrap up, and I will be looking at the questions that come in. So keep them coming before Hillary finds a way to like hit me on the side of the head for taking all the time.
Thanks, Greg. As a reminder, I'm Hillary LaFew. I'm an associate in our LA office. And I've been spearheading the filing a lot of these 1581I complaints. And so I'm going to talk a little bit more on the practical side, next steps, what do you actually do? But before you get to the practical steps, of course, there's always things to consider. So we'll start there. The first step, which really is step 0, is identify all your importers of record. As Greg mentioned, you don't have a right to refund unless you were the importer of record who actually paid the tariffs. So various companies will be in different positions on this issue. You may have actually paid the tariffs, or you may have had costs related to the tariffs passed down to you, in which you're in a little bit of a different position, and there are still avenues, maybe contractual avenues or just relational avenues to recoup some of those costs. And we've been advising companies on that as well. But for these purposes, you really need to identify who are the importers of record. Once you've done that, then you can mine the ACE data. If you're not familiar with ACE, it's the primary system Customs uses to process imports and exports and all of the information that goes with that. So they have records in ACE of to the penny of what each entity has paid in IEEPA tariffs. You can identify specifically the IEEPA tariffs by running a report on your entry date, beginning whenever that is. If you want to really encompass all of the IEEPA tariffs, start on February 1, which is prior to the first one that came into effect. And then filter for HTS Chapter 99 tariff provisions that are associated with the IEEPA measures, which are listed here. And then you can create this centralized tracker so that you're aware of all of the tariffs and the amounts and the dates that they were paid, which leads into step 2. Given what Greg was talking about in terms of the belt and suspenders approach, or if it isn't cost effective for you to file a 1581I action, you want to be aware of your liquidation and protest deadlines. So as he mentioned, entries automatically liquidate around 314 days generally, and then you have another 6 months, 180 days after the liquidation date to file a protest. So it's important to keep track of those deadlines to make sure you're exercising your rights there as, again, either a backup or as your first line of defense and preserving your right to refunds. Another key step is to stay updated on developments. We've been sending out a lot of communications, but you can get communications directly from the government. Greg mentioned the CSMS alerts. And again, this is a key method by which Customs releases updates to the importer community. So for example, 2 of its most recent updates concerned the ending of the IEEPA tariffs and the imposition of Section 122 duties. So there are kind of the annoying updates of just system changes, but there are also very substantive updates. You can just go to the Customs website to sign up for those alerts. Also keep tabs on the Federal Register and executive order announcements. Those are the first notice of what Customs has to take action on. So staying up to date on those can give you a heads up as to what's coming down the pipe. And then we're still in a high tariff environment. Even though IEEPA tariffs are gone, we still recommend that you be up to date on all of your Customs compliance and be audit ready. Ensuring that you're in a good position to know what you've paid, where you've paid it to, and again, to be tracking the deadlines associated with those payments. We'll talk about this more in part 2 of our webinar. So if you want to know more what it looks like to get Customs compliant, I highly recommend you attend part 2. And then in general, I think all of these steps set you up well to validate that you have complete and accurate payment of your IEEPA tariff refunds. The more information you have on the front end of what you've paid, the better you'll be set up to actually know if you're getting the accurate payment of your refunds. And one other note with ACE data, if you, again, because this is where you're going to get that to the penny information. If you don't have an ACE account, which we highly recommend you have your own ACE account as a company, you can reach out to your broker to pull that information. But that, again, should be in the immediacy. It's really important for you to have your own access to that information. So some takeaways from those considerations and what Greg was discussing: refunds are not automatic. The method and the scope will be determined by the CIT. And we believe that filing a 1581I action provides the strongest procedural protection. It provides that certainty that you may be looking for. And then for those who it either doesn't make sense monetarily to file a 1581I, or for those using as boot and suspenders, belt and suspenders, an administrative filing should be used at minimum. And then, as Greg mentioned, the market monetization options exist with selling your claims, but we encourage you to exercise caution if you come across these offers, as some of the terms are not always favorable in terms of you'll end up doing a lot of the work to get your refunds and then not actually get the 100% on the dollar benefit. So again, we encourage you to be prepared. The companies that are acting early will be in the best position to get their full refunds and to get them in the most timely manner possible. So what does it look like to actually file a 1581I action? There are some basic threshold requirements. The claim has to arise from the federal laws governing tariffs or customs administration, which this does. There are no jurisdictional avenues that are adequate. The CIT has confirmed that it has jurisdiction here, and the Supreme Court, in remanding to the CIT, has confirmed that. The importer is the party that has suffered the financial injury, and this is where we emphasize that the plaintiff has to be the importer of record, the party that actually paid the IEEPA duties, and the action is timely, which it continues to be. As we discussed, the statute of limitations for a 1581I action is 2 years, so it's unclear when that limitation period begins. So the earliest would be the date the duties were paid. So at this point, we see a 1581I action as well within the statute of limitations. We aren't certain as to what sort of refund mechanism the CIT will order, which is why we continue to encourage companies to get complaints in quickly. But either way, the actions are timely. So the case will be filed in the Court of International Trade, the CIT. And again, the Supreme Court's remand, as well as the continued acceptance of these filings, we've seen a ton more filings this week, even strengthens the argument that jurisdiction is appropriate under 1581I. So when you prepare for a filing, you'll need to identify the importer of records, parent corporations, all publicly owned companies. These are information, this is information that is required for corporate disclosure. And you also need to identify the principal place of business. We've just been including the city and state, basic information. Identifying the real party of interest, if it's not the filing importer of record. We haven't actually come across this. This is more relevant in a situation where the trade association is the filing entity as opposed to its members. And then whether the company has already requested CBP to extend the liquidation date, and whether you've already filed PSC actions. And then the key thing is that we've had companies kind of struggling to find their entry-level data at this point, which it's not required at the time of filing. We don't need to know exactly when or how much the tariffs paid were. However, again, it's important to understand that that information to determine whether an action is appropriate for your company. If you've only got $50,000 worth of IEEPA tariffs, a filing may not be cost effective. And then another key is that you can file on behalf of multiple plaintiffs in a single complaint. So if you've got a few companies in a portfolio or a holding company with several companies, it's not necessary to file individual complaints on behalf of each of those importers of record. We throw them all into one complaint, and you can file on behalf of multiple companies all at the same time that way, making it more efficient for you and for us. Now, John is going to jump in and he'll talk a little bit about the forward-looking piece of this.
Perfect. Thank you, Hillary. Hi, everyone. John Turley. I'm going to talk a little bit about what's happening now. When the IEEPA tariffs were originally imposed last year, it took only a couple days before the litigation was filed. They challenged it. The court system worked beautifully. They expedited everything, and it took only about a year to get a decision. The Trump administration works faster. It took them about 2 hours to come up with some other options to have. They had some time to think about it, but they now have in place backup measures. So we're going to talk a little bit about that. So what they did is after the invalidation of the IEEPA, they immediately pivoted to another statutory authority, and specifically it was Section 122 of the Trade Act of 1974. The Trade Act, unlike IEEPA, does mention tariffs, so we have something to work with there, but it's still a question of whether it's perfectly suitable. More specifically, Section 122 allows tariffs, and I'll be reading here, to deal with large and serious United States balance of payment deficits, to prevent an imminent and significant depreciation of the dollar in foreign exchange markets, or to cooperate with other countries in correcting an international balance of payments disequilibrium. So that's supposedly what Section 122 allows the imposition of tariffs for. So the way that it works, as you can see from the bullets, is that under Section 22, the president can impose tariffs of up to 15%, can also impose quotas to remedy issues, or could do both. One of the advantages of Section 122 over Section 301 and Section 232, which we'll talk about shortly, is you don't have to have a long investigative process. They can do this very, very quickly. But while it's very broad, it's very quick, it's also temporary. So the president can only keep those tariffs in place for about 150 days. It is possible for Congress to approve a longer time period, but there just doesn't seem to be the appetite for tariffs in Congress, so it likely wouldn't work. So that what this means is it's really a bridge. It's not the end result of what's going to happen. Rather, I think other measures are going to take place. Historically, Section 122 hasn't really been used. President Nixon, did impose them for about four months, and that's what spawned Section 122. And as you've probably read, the big question is this even legal? Inevitably, we may be back here a year from now talking about the decision on Section 122. As many commentators have noted, ever since the U.S. went to a floating exchange rate, that has basically solved the problem of these balance of payment deficits. But nonetheless, if we were going to predict how this would come out, understanding there would be litigation, we think that they might be able to sway one or two justices over, and that's because Section 122 does mention tariffs, And the court generally gives a lot of discretion to the president to decide whether or not there really are fundamental international payments problems. So we'll see where it goes, but certainly we expect that there will be some litigation. So how is this actually played out in practice? Little bit of an interesting development. The basic roadmap is immediately hours after the Supreme Court decision, there was an executive order imposing 10% under Section 122. That was on Friday. On Saturday, President Trump comes out in a statement on Truth Social and says, no, we're going to move it up to 15% immediately. There wasn't an executive order that changed that. So operationally, it remains at 10%, although the Trump administration has said just yesterday that they are going to work and selectively impose the 15%. So we do expect in the next couple of days, maybe next week, there is going to be that rise from 10% to 15%. Let's see. The one thing I should also note is that under the Section 122, there is an on-the-water exception. So it does not apply to those goods that were actually in transit on the way over. So that's something to think about. That ends February 24th at 12:01 a.m. Eastern Time. But again, those goods had to be in transit. Of course, like everything, all the other tariffs programs that have come out, this creates uncertainty. It's going to create pricing volatility, and we'll have to see where it goes next. So in addition to all the things that happened with the IEEPA decision, it did not happen in a vacuum. There are all kinds of other tariff issues, and rather significant tariff issues, that are still ongoing and still need to be determined. So we want to talk a little bit about those. As I mentioned, the Section 122 tariffs, the status of that is unknown, whether they're going to be deemed lawful or unlawful. We'll have to see how that plays out in the courts. It'll probably be very similar to the IEEPA litigation. One thing it does change a little bit is we use the term secondary tariffs. And it takes away some of the ability for the president to use tariffs as a bludgeon for things that he doesn't like. And that may be as a negotiating tool. And using one example, it was the threat because of a commercial that came on from Ontario, but it's also the threat from India, for example, that we don't want you buying Russian oil. So to stop you from doing that, I'm going to impose an additional 25% on top of your 25%. So under IEEPA, that gave the president a lot of flexibility to use tariffs as a very strong negotiating tool. He'll be able to do that somewhat under some of the other authorities, and in particular, I think Section 301. But as a general matter, he's not going to be able to do the day-to-day. We want a country to take certain action. Here's what we're going to do. We're going to impose tariffs if they don't. Under the current program, there are a lot of tariff programs that have been put into place. The administration has said that they want to work with the countries that have already struck deals to make sure that those frameworks stay in place. It will likely be a combination of various tariff programs to make that work. Some countries, such as in the UK, they have the 10% rate. So if they were an increase to 15, that would be an increase of 50%. While you have other countries, such as Vietnam, which is at a 20% negotiated rate, and even the 15s wouldn't cover that. So we're going to have to see how that plays out. It's an open question of how aggressive countries that had entered into such agreements on the premise of IEEPA, how they're going to approach the negotiations. Some other really big issues to think about: Section 232 on steel, aluminum, copper, timber. There are some open issues there. One of the questions that we've been getting all the time is on the steel content and calculation of aluminum content in products. The government has suggested that they're going to shift from the very challenging and almost unworkable process of trying to identify what percentage of your tractor is steel and what is not. They seem to be moving more to an HTS specific rate, so that derivatives that almost invariably are 100% made of steel may have the 50% rate, whereas other products that have less steel content would be lower rates. Also, the USMCA negotiations are ongoing, expected to be completed by July 2026. Even that is a huge question of what's going to happen there, whether they are going to even keep something like the USMCA or whether they're going to negotiate separately. Okay, so we're going to talk a little bit about the future of tariffs. I'll go through these slides relatively quickly to give Greg some time to respond to any last questions that we have. But as we discussed before, Section 122 is the bridge, not the destination. It is broad, but it also is limited temporally to the 150-day period. Therefore, we expect that they're using this bridge to get to other more established, more durable programs that include Section 232 and Section 301. In particular, we think that they're going to accelerate investigations under Section 232 that they have started previously. The list, I'm just pulling this off online. Section 232 investigations have already been started for robotics, industrial machine, personal protective equipment, medical equipment, wind turbines, unmanned aircraft, polysilicon, processed minerals, pharmaceuticals. And there are going to undoubtedly be a lot more of those types of sector-specific investigations. I think currently, just with the investigations they cover something like 40 to 60% of all trade transactions to begin with. In addition to that, they will launch new Section 232, and one of the more important tools we think is they're going to be using Section 301, which is more country specific, and it will give the president the ability to be flexible and be able to change some of the rates more quickly, maybe not as quickly as under IEEPA, but on a relatively expedited time frame. So really quickly, 232, one of the questions may be, why didn't President Trump start with these immediately? And that is because Section 232 is more durable because it is more of a procedural. There are certain requirements. Most importantly, it requires an investigation by the Department of Commerce. That investigation typically takes 270 days. I have no doubt that they are going to expedite that. And once they have those in place, then they can use them similar to what they have done already when President Trump used Section 232 in his first term for steel, aluminum, and more recently with copper and timber. So we do expect the use of Section 232. We also think that he is going to pivot to Section 301. Section 301 is probably familiar to most people on the call because it has been used for years under the first administration, focused on China. Section 301 deals with unfair trade practices, discriminatory practices, failing to protect intellectual property, technology, invalid technology transfers, things like that. So it's a very broad-based section that allows the president to impose tariffs. Like the Section 232, it does require an investigation, this time by the USTR, a notice and comment period. So it, again, is not, unlike the IEEPA, which President Trump was able to use very, very quickly and very focused. Section 301 is something that we expect him to use, get in place with many countries, especially those which we don't have trade deals, so that he can set a range, whether that range is consistent with prior trade deals. Again, just to summarize, it's going to remain a high tariff, high penalty environment. So it's critically important that you have the right customs compliance program in place. Section 122 short-term, Section 301 and 232 are going to be the primary tariffs we think that he's going to pivot to. It'll take a little bit longer, but it should provide a little bit more certainty in that these tariffs will likely not be overturned. So I will, with that, I'll flip it over to Greg to answer the final questions and to conclude.
Okay, very quickly, yes, we will be circulating the slides. I guess one or two people said they weren't able to see the slides. We will circulate them. Also, we have a 5-part IEEPA week series on managing the aftermath, which goes into all of these topics. Plus, you get the ChatGPT generated customs tariffs at no extra cost, which were really hard to get because ChatGPT kept saying I was advising people to engage in customs fraud, and I would have to argue that they were for purposes of education. Secondly, the cost for the filings. We've been handling these. We have permission from the firm to do these for $40,000, plus there's a $400 CIT filing fee, and that covers everything like the briefing, coordination with counsel, everything up until the end, which we're able to do because we're handling these for a bunch of different companies. So that is an all-in cost. So if you want to talk about that, potentially filing one, we'd be happy to discuss that with you. Next question, can you file a 1581I if you have filed PSCs? The answer is yes. They're parallel, they're not mutually exclusive options. The next question, should we wait for government guidance before filing protests? I would say yes. There's no reason why you have to file a protest against liquidation early. And as long as you're tracking it and not going past that 180 days past liquidation, there's no reason why you have to file early. In fact, since you can file on a batch basis, it might make more sense from that perspective to handle it as well. Next question is, what are the odds that the government is going to make people fight for it? I think the odds are probably fairly high, but the government is going to be constrained because of their past representations to the CIT that they wouldn't oppose reliquidation, and they're before a court, which is a little bit skeptical of them. Plus, so there's limited grounds for them to do so. I do expect that they're going to push for some kind of opt-in type mechanism, vacuum up all those nickel and dime IEEPA tariffs, if, from the seat cushions that will add up to a lot of money overall to the government. So if they have some kind of opt-in mechanism. That being said, CBP has the ability to give everybody a full refund, and it can be done electronically. So they could do it. It's just a question of whether they're willing to do it. Because people ask, like, what happens at the end of the 150 days? Can the president create like a new emergency? We don't see that happening. The Trump trade team knew that this was potentially coming, and they put in place Plan B, which is the Section 232, and Plan C, which is the Section 301 tariffs. Even the president in the State of the Union in the press conference said, yeah, well, maybe we should use these from the beginning. Maybe they're better even. So they're clearly going to pivot to that. And then the last question was, what if you're not an importer of record? What can you do? And that question is a main topic of the Part 2 webinar, which I believe is next Wednesday, where we're going to cover the aftermath of the IEEPA tariffs. Like, what can you do, behind the scenes when dealing with counterparties? What should your strategies be for customs compliance? What should you be doing to, to go beyond the, positioning yourself to deal with like the supply chain issues? Should you be lobbying? There's lots of issues that are not just limited to like the importer of record, and we'll be covering that. And then lastly, to hit the last question that came up, where someone asked, is the 40K just to file? How far into the litigation does it cover? It covers to the end of the litigation. We saw from being on the plaintiff steering committee for the 301s that people were looking for budgeting certainty, and we basically I convinced the firm to take a gamble. I said, look, there's going to be so many of these that we'll be able to handle them at a reasonable cost, just while we spread the time over everyone. So it covers like the briefing and coordination with co-counsel, everything up until the CIT issues and order, which we're hopeful and pretty confident will be to refund the money to the people who have filed. And then one last question came up: what happens if you file for 1581I protective action, and while the case is in limbo, you decide you want to sell your rights to the tariffs? I don't know the specific answer to that, but I know if I were looking to purchase these claims, I would either be offering more to companies that have filed 1581I protective actions, or I would be saying that that's a requirement because you would want to maximize the chance at a speedy outcome. Again, we view the 1581I as being something that is definitely going to happen. It's just a question of when and what mechanism, and so this is creating another avenue. And the 40,000, to be clear, someone just asked this, is for the 1581I filing of the summons and complaint, but also all the related litigation for that. So at this point, we actually are technically 4 minutes over, but since I'm benchmarking myself against how long a typical President Trump speech is about tariffs or any other issue, I'm saying that we actually finished early and on time, and that this is exactly the most beautiful possible 1581I tariff presentation that anyone has ever seen, and that it clearly did not go over. If you have any other questions and would like to talk about this, then we, including the 1581Is, we would be happy to do so. And by the way, with regard to the filing, we can include all affiliates, to answer one more question that came up. So if you have 4 companies that are affiliated, we would just include them all as named plaintiffs, and we cover them all within the single 40,000, because we can include them all in one complaint. So again, if you have any questions, this is all proof that the Chinese proverb or curse, may you live in interesting times, clearly was not intended for the tariff world. We were all longing for the days when customs and compliance was very simple and easy, and people worried whether or not their goods were subject to a 3.2 or a 3.4% classification under the HTS. Those days are not coming back for the next couple of years, and perhaps ever. So if you have any questions, please feel free to reach out to us. And with that, we will bring this to an end, and we hope to see you all next week on part 2 of the webinar.